9. Common Law Review in Two Common Law Systems. A. England. In this chapter, I intend to show that common law review can operate not just in the abstract, but in actual common law legal systems. Given the prominence of American cases in the previous chapter's discussion, it might be tempting to think that if common law review can work anywhere, it can work only in the United States. This is incorrect. Common law review may fit most smoothly and easily, although certainly not without objection, into U.S. legal culture and practice. But common law review can fit even within the English legal tradition. The English common law system has the most restrictive notion of stare decisis, the most monolithic conception of legislative supremacy, and the least powerful judiciary in the common law world. The confluence of these factors has led one jurisprudential provocateur to allege that England is more truly a civil law than a common law nation. While this goes too far, it is one of the great ironies of legal history that the nation of the common law's birth has been perceived historically as the common law nation with the most anemic common law judiciary. Of all existing common law systems, England's appears to be the least hospitable to the principle and practice of common law review. Nevertheless, I will argue in this chapter that common law review can adapt even to the English environment. And if common law review can work there, it can work anywhere where there is an existing common law system. I should begin by explaining, just in case it is not already apparent, why I will not discuss the Human Rights Act of 1998 and its explicit incorporation into English law of the European Convention for the Protection of Human Rights and Fundamental Freedoms. As I have indicated, I am interested in examining common law review, not constitutional review. That is, my arguments address the common law's intrinsic constraints on abuses of legislative or executive authority, rather than those of a written constitution. So, to the extent that the Human Rights Act and the European Convention represent an English Bill of Rights, they are immaterial for my purposes. Moreover, even though certain English judges apparently believe, or perhaps believed, that the absence of a written English constitution, such as the Human Rights Act and the Convention might provide, presents an impediment to their exercise of vigorous judicial review, many English judges view the Human Rights Act and the Convention as largely superfluous, because English common law long ago articulated and protected the fundamental rights, principles, and values identified in the Convention. England's unwritten constitution is, in other words, a common law constitution, which subjects the government to the rule of law and protects individual rights and fundamental values from infringement through abuses of power. Demonstrating that common law review can operate in England requires overcoming the doctrines of stare decisis and legislative supremacy as they are currently understood by English lawyers and judges. I will begin with stare decisis. 1. Stare decisis. Since the issuance of the Practice Statement of 1966, there is no question that the English House of Lords may depart from its own precedent. Therefore, horizontal stare decisis would present no extraordinary barrier for the House's acceptance of common law review. The matter is less clear where the Court of Appeal is concerned. Following the House's decision in Davis v. Johnson, most English lawyers assume that the Court of Appeal is bound to follow its previous decisions in all civil cases. But as Sir Rupert Cross and Professor James Harris explain, whether the Court of Appeal is absolutely bound by its prior rulings depends on one's view of stare decisis as a legal rule prescribed by the House of Lords or as a legal rule defined by judicial practice. Both views find support in English law and legal tradition. Cross and Harris point out that the rule that the Court of Appeal is, in general, absolutely bound by its past decisions is the product of the mid-20th century. In fact, the Court of Appeal did not consider itself invariably bound by its own prior rulings for much of the 20th century. The exceedingly austere version of horizontal stare decisis found in England today is of relatively recent vintage. If stare decisis is a legal norm whose source is judicial practice, as I have argued earlier, then England's version of stare decisis need not be so sclerotic. Only the conceit of the present prevents English judges and lawyers from embracing the more supple and discriminating view of precedent that prevailed in the not-too-distant past. So a judge of the English Court of Appeal can find a legitimate basis in English law and legal tradition for departing from a previous Court of Appeal decision. As with the House of Lords, horizontal stare decisis need not present an insuperable obstacle to endorsement of common law review by the Court of Appeal, or at least one of its judges. I promise to apply common law review to common law systems as they actually exist today. One might object that by arguing that the Court of Appeal could rely on older case authority, rather than prevailing current understandings, I am sidestepping the issue. But this misapprehends the meaning of judicial practice as the basis for stare decisis as a legal standard. It is true that it would be a change in current practice for a Court of Appeal judge to depart from a Court of Appeal precedent, but judicial practices and practice-based legal doctrines can change only through judicial innovation. To say that this would be a change in judicial practice is not to say that the change would be improper or legally unfounded. Moreover, the presence of legal sources that support this change only strengthens the basis for the new practice. In fact, as I just discussed, this is not a new practice at all. It is a return to a previous practice, improvidently discontinued. Horizontal stare decisis and the current practice of lockstep adherence to its own precedent need not, then, prevent the Court of Appeal from adopting common law review. What about vertical stare decisis? In its own subdued way, the Court of Appeal has occasionally declined to follow decisions of the House of Lords. For example, in Skorsch-Meyer GmbH v. Hennen, the Court of Appeal reconsidered the long-standing rule in English common law that an English court could award a judgment for money damages only in pounds sterling. Hennen involved a claim by the plaintiff, a German corporation, for the balance of an account owed by the defendant for goods delivered to the defendant in England. The defendant had made a partial payment to the plaintiff in Deutschmarks, the currency stipulated in the contract. When the defendant failed to pay the balance owed to the plaintiff sued the defendant in England and sought the payment in Deutschmarks in accordance with the contract, relying on the English common law rule. The trial court ruled that it could not award damages to the plaintiff in any currency other than sterling. On appeal, the plaintiff argued that Article 106 of the Treaty of Rome, which was incorporated into English law via the European Communities Act of 1972, required English courts to give judgments for creditors residing in other member states in the creditor's home currency. Although the Court of Appeal agreed with the plaintiff about the effect of the treaty, the court began its decision and spent most of its discussion addressing the common law rule. Recognizing that the English rule requiring that judgments be given only in pounds dated back at least to the early 17th century, and acknowledging that the rule had been reaffirmed by the House of Lords in Reunited Railways of Havana and Regla Warehouses Limited. The Court of Appeal nonetheless refused to apply the traditional common law rule and awarded judgment to the plaintiff in Deutschmarks. In reaching this result, the Court of Appeal relied on an even older common law principle. Cessante ration legis cessat ipsa lex. The House of Lords was sharply and predictably critical of the Court of Appeal's refusal in Hennen to follow United Railways of Havana. In Meliangos v. George Frank Textiles Limited, Lord Wilberforce chided the Court of Appeal, saying, "It has to be reaffirmed that the only judicial means by which decisions of this House can be reviewed is by this House itself, under the Declaration of 1966. This rebuke notwithstanding, Wilberforce and the rest of the House then went on to overrule United Railways of Havana and affirm the rule announced by the Court of Appeal in Hennen. Hennen and Meliangos are not the end of the story. Over a decade after Meliangos was decided, the Court of Appeal again declined to follow a decision of the House of Lords. In Pitales v. Grant, the Court of Appeal refused to apply a rule established by the House almost 100 years before. We hold that the rule in Smith v. Baker and Sons 1891 AC 325 ought no longer to be applied. We are conscious that it may seem a strong thing for this court to hold thus of a rule established by the House of Lords. but where it can see that the decision of the higher court has become obsolete, the lower court, if it is not to deny justice to the parties in the suit, is bound to say so and to act accordingly. The House of Lords has not, to date, responded to the Court of Appeal's statement in Petalis. As Cross and Harris rightly observe, the rare refusal by an English lower court to follow a decision of a higher court is not the death knell for England's common law system. On 2 recent occasions, the Court of Appeal has declined to follow decisions of the House of Lords, and the House has reacted in an appropriately admonitory manner, but the common law is intact. Cross and Harris provide a healthy dose of historical and doctrinal perspective concerning the operation of vertical and horizontal stare decisis in the English legal tradition. Along with the decisions in Henin and Petalis, they demonstrate that not all English judges and lawyers turn paroxysmal at the suggestion that English judges might exercise their own best independent judgment in extreme cases where the enforcement of existing precedent would lead to an unjust result, even when this means that a lower court judge might refuse to follow a higher court precedent. In other words, English law provides a basis for the acceptance of common law review at all levels of the English judicial hierarchy, even in the face of a restrictive understanding of vertical and horizontal stare decisis. I have tried to show that common law review is a viable legal doctrine with a basis in English law and judicial practice, which can overcome horizontal and vertical stare decisis, even in their most rigid manifestations. I have argued that England, like the United States, permits its judges, including its lower court judges, a meaningful measure of independent judgment and a theoretical ability, sometimes evident in practice, to refuse to follow precedent that leads to untoward results. For those who remain unconvinced or who reject the source of stare decisis in judicial practice, the Court of Appeal could not reject its own prior decisions, or the decisions of the House of Lords, in the exercise of common law review. For these contrary-minded individuals, common law review would be available only to the House of Lords. Even these individuals must concede, however, that nothing in the English doctrine of stare decisis prevents the House from refusing to follow its own precedent, if a precedent struck one or more of its members as powerfully and irretrievably unjust. 2. Legislative supremacy. In England, legislative supremacy is called parliamentary sovereignty. This is because in England to be sovereign was to be supreme, and to be supreme was to be uniquely powerful. As Geoffrey Goldsworthy explains, this part of the English cultural subconscious was formed over centuries in which the same idea was repeated as a legal litany. Traced through hundreds of years, the idea is this: there must be absolute, unlimited, and uncontrollable power lodged somewhere in every government. The question then is only this: where is its most safe resting? In England, it was lodged in the King, Lords and Commons and Parliament. The English predisposition to view governmental power as necessarily localized in a singular governmental body evolved, almost certainly, from its monarchic legal and political history, as Goldsworthy carefully documents. What was once lodged in the person of the monarch came to be lodged in the body of Parliament, and it follows from this conception of parliamentary sovereignty that the judiciary was therefore subordinate to the legislature. England's legal history translated directly into its legal and political theory. Thomas Hobbes's claim that every legal system necessarily presupposes a sovereign lawmaker, and John Austin's command theory of law, the concept of law as the commands of an uncommanded commander, are evident in the thought and language of England's proponents of Parliament's sovereignty as unique and unassailable. Here is an example. A sovereign power necessarily existed at the apex of any legal system. It must have necessarily a fountain that derives it to all others, and receives it not from any. Therefore a well-spring it follows there is, and a supreme head of justice, whereunto all are subject, but itself in subjection to none. This is Austinian legal positivism. The antecedents of this commitment to a legally limitless sovereign power can be found in Bodden's writings, and its torch was passed and carried into contemporary English thought by Dicey. While the Bodinian Austinian Dicey conception of parliamentary sovereignty dominates English legal minds today, it does not control them all. Some judges and theorists have raised criticisms of parliamentary sovereignty as a political and legal doctrine and as an allegedly ineluctable fact of English political and legal history. For example, Trevor Allen argues, Dicey's Austinian positivist assumptions and those of his adherents have skewed our wider constitutional vision, and the confused condition of contemporary theory seems to be the consequence. It is a question of the nature of public law and the legitimacy of the judicial function. As Allen goes on to explain, the continuing debate among scholars and judges about the proper conception of judicial review and the ultra vires doctrine in English constitutional law and theory is linked directly to an underlying disagreement about the historical and theoretical basis for absolute parliamentary sovereignty in English legal thought and practice. This continuing debate and this underlying disagreement echo the dispute over the proper reading of bonum as either a version of statutory construction or a vision of judicial review, and the view of the separation and allocation of governmental powers that attends each reading of bonum. On the Dicey model, judicial review of legislation in England is limited to an effort to realize legislative intentions. In the lexicon of English constitutional theory, this is called the ultra vires model of judicial review. According to the ultra vires model, judges may examine the actions of administrative bodies only to ensure that they have not exceeded their delegated authority. If the administrative agency has acted within the scope of the power granted by Parliament, English judges are powerless to review that agency's action, because to do so would be to usurp the absolute sovereignty of Parliament. Those who defend the ultra vires model claim, following Dicey, that judicial review can be justified solely by the judicial attempt to enforce parliamentary intentions. In contrast to the ultra vires model, other theorists defend a common law model of judicial review that is justified without reference to legislative intention or authorization. By this brief summary, I do not mean to create the impression that there is only one version of the ultra vires model, or the common law model, or indeed, that these are the only two models of judicial review available in English constitutional theory. Vires-based models of review proceed from the assumption that English courts cannot invalidate primary legislation. They are limited to the interpretation and enforcement of legislation in an effort to apprehend and effectuate parliamentary intention. Common law theories, especially as espoused by the so-called strong critics of vires-based models, do not accept this basic premise. These theories and theorists might permit judicial invalidation of parliamentary statutes on rare occasion. Furthermore, as Allen notes, even if one accepts the vires-based model's premise that courts cannot invalidate primary parliamentary legislation, English courts could still refuse to apply unjust or unconstitutional statutes in particular cases. This is completely consistent with the distinction between elimination and repudiation, which I discussed earlier, and with common law review's commitment to the latter. Allen emphasizes that the view of fettered judicial authority and autonomy presupposed by the ultra vires conception of judicial review undermines the traditional role of the courts in defense of individual rights. In fact, according to Allen, the attenuated role of common law courts, assumed by current English legal practice, threatens the constitutional legitimacy of England's governmental order. If there were ultimately no limits to legislative supremacy, as a matter of constitutional theory, it would be difficult to speak of the British polity as a constitutional state grounded in law. Although the form of the separation of powers may vary between constitutions, the independence of the superior courts from government and legislature seems fundamental to the rule of law. It follows that if we deny all restrictions on legislative competence, even in respect of the adjudication of particular cases, we thereby reject constitutionalism. Absolute parliamentary sovereignty and correlative judicial subordination are neither historically inevitable nor constitutionally desirable. For over 300 years, the independence of the English common law judiciary has allowed it to develop and maintain English public law doctrines and values. England's authentic common law heritage has always recognized that judges must be capable of and amenable to an exercise of independent review of legislative and executive action to ensure the preservation of the rule of law. Allen argues for just this sort of English judicial independence, and his writing offers strong and quite specific support for the principle of common law review, as I have presented and defended it. It is hard to see how judges, in a constitutional democracy, can escape the responsibility to settle the limits of legislative power. They must, of course, employ the tools at hand. Some constitutions are more aptly framed than others. A written constitution of some kind is generally better than none. In the end, however, a court must decide whether or not it is a constitutional court, in the sense that it acts under, and exists to safeguard, a constitution, in which powers are reasonably distributed between the different organs of government. The grant of unlimited powers to the legislature, even in relation to specific individuals, amounts to the abnegation of constitutionalism, and therefore to a renunciation, in all but the most arid and formal sense, of the rule of law. Moreover, this is not merely an abstract constitutional logic. It is the logic of the common law. It is through the development and experience of the common law that we know the ingredients of a fair criminal trial, and discern the point at which a retrospective penal statute strikes unacceptably at the heart of judicial power. It is not, of course, in the common law tradition to define such a point conclusively in advance. But it is the responsibility of common law judges to reserve the right to reject a statute which is sufficiently abhorrent. To Allen's specific arguments and observations, I will add two further reactions. The first is that sovereignty and supremacy strike me as remarkably tendentious and unhelpful concepts when attempting to understand the relationships among organs of government in healthy constitutional democracies. As Mark Walters explains, the nature of Parliament's authority is described better as omnicompetence than as omnipotence or absolute supremacy. Contrary to the rudimentary notion of legal power evident in Austin's theory of law, there is no need for a single source of legal power, and there is no necessity that this source be legally boundless. As I have already mentioned, in healthy governments, the legislature and the judiciary are not engaged in a war of wills to grasp and maintain legal and political power over the populace. Powers are shared and exercised according to institutional aptitude and constitutional allocation. The idea of absolute parliamentary sovereignty sometimes seems to be dogmatically superimposed on the genuine state of affairs in English constitutional structure and then subsequently rationalized or reconfigured. In England, as in all common law nations, legal power resides in different governmental organs with different legal and political roles and responsibilities. It would be well for English lawyers, judges, and theorists to remain open to a different, more accurate conception of parliamentary and judicial powers, as those powers are actually exercised and experienced. Some suggest that this process of reconceptualization has already begun. According to these writers, the English constitutional paradigm of absolute parliamentary sovereignty is shifting to a bipolar sovereignty of the Crown in Parliament and the Crown in the courts. To be sure, many English neo-parliamentarians would disagree, cleaving to the status quo. But my point here is to stress that the idea of a more balanced, plural English government with an independent, robust judiciary is not a picture unfamiliar to English legal history, theory, or practice. The changes I suggest are not revolutionary, even in the Kelsenian sense. Or if they are, then they represent a reactionary revolution. What I mean by this oxymoron is that this revolution would return England's legal system and culture to its roots, rather than plant an entirely new tree. My second reaction also begins by recalling my discussion of absolute parliamentary sovereignty as having its theoretical basis in Austinian legal positivism. If legal theory can ever assist political and constitutional theory, perhaps here is an opportunity. Legal philosophers widely and routinely dismiss as simplistic and misleading Austin's conception of an absolute sovereign, unbounded by legal constraints on the exercise of its power. Meanwhile, a version of just this sort of sovereignty persists in Britain as the prevailing conception of Parliament's legal authority. If Austin's notion of a legally unlimited sovereign is objectionable in theory, why is it so vigorously defended in practice by so many English lawyers, judges, and scholars? The answer seems to be some combination or variation of history and tradition. It might seem that the idea of Parliament as able to, as William Blackstone put it, do everything that is not naturally impossible, has become irretrievably embedded in the collective psyche of the English legal community. Nevertheless, as I have tried to explain, views among contemporary scholars differ on this issue. When we consider it as a historical matter, there is reason to doubt the necessity of viewing parliamentary sovereignty as absolute sovereignty. When we consider the issue as a theoretical and practical matter, the doubts only intensify. This debate will continue for as long as Parliament continues, but English lawyers can no longer respond to doubts about parliamentary sovereignty with bromides about the way it has always been or must be. An English lawyer might object that the previous discussion of parliamentary sovereignty is purely academic. Although some prominent English judges have argued that they should have the power to invalidate legislation, as American judges do, they have not made this claim from the bench. Parliamentary sovereignty is a feature of England's constitutional architecture, and English judges do not possess the power to invalidate parliamentary legislation. Whatever the arguments against sovereignty or in favor of judicial review may be, I promise to discuss common law review in the context of the English legal system as it exists today, and a critic might object that I have not yet done so. While it seems to me that this objection ignores the thrust of Allen's and others' arguments, I accept, for the purposes of argument, that I have more to do, and I can do more. Support for common law review can be found in decisions of the House of Lords, or at least in the speeches of some of their lordships. A frequently cited modern starting point for discussing English judicial independence and resistance to absolute parliamentary sovereignty is the House's Annis-Minnick decision, which I discussed in the previous chapter. Annis-Minnick is not, however, the only available support for a doctrine of common law review derived from decisions of the House of Lords. Even stronger support can be found in Sims. Sims involved prison inmates convicted of murder who, while incarcerated, met with journalists interested in investigating and publicizing the prisoners' continued protestations of innocence. After learning of the reasons for the journalists' visits, the prison officials prohibited the journalists from visiting the prisoners unless the journalists agreed in writing that they would not use for professional purposes any information obtained. The legal basis for the prison officials' position was Prison Service Standing Order 5, Section A, Paragraph 37, 1996, which was issued pursuant to Rule 33 of the Prison Rules 1964 under authority granted by the Prison Act of 1952, Section 471. The journalists refused to sign and were denied further access to the prisoners. The trial judge granted an application for judicial review of the Secretary of State's decision to require journalists to waive in writing their professional interests prior to being granted meetings with prisoners. The trial judge determined that a blanket prohibition against any journalistic use of information obtained during a visit with a prisoner amounted to a violation of the prisoner's right to freedom of expression, and, consequently, that paragraphs 37 and 37A of Prison Service Standing Order 5 were unlawful. The Court of Appeal reversed the trial judge's determination, but the House of Lords reversed the decision of the Court of Appeal. Lord Steyne's speech is most important to my argument. After reviewing the facts and arguments of the parties, Steyne began his legal analysis with the right to freedom of expression. In Steyne's opinion, this right is the primary right in a democracy without which an effective rule of law is not possible, and freedom of expression is a common law right, one of those fundamental common law rights recognized by English judges to be of constitutional dimension. This common law constitutional right of freedom of expression is crucial, according to Steyne, in exposing and curtailing abuses of governmental power. The free flow of information and ideas informs political debate. It acts as a brake on the abuse of power by public officials. It facilitates the exposure of errors in the governance and administration of justice in this country. The applicants argue that in their cases the criminal justice system has failed, and that they have been wrongly convicted. They seek, with the assistance of journalists, who have the resources to do the necessary investigations, to make public the wrongs which they allegedly suffered. The prisoners are in prison because they are presumed to have been properly convicted. they wish to challenge the safety of their convictions. In principle, it is not easy to conceive of a more important function which free speech might fulfill. Steyn understood the importance of a common law right in restraining abuses of state power and in preventing or correcting injustice, specifically in rectifying the possible wrongful conviction of an innocent person, probably the greatest injustice of which a legal system is capable. At the conclusion of his speech, in which he provides his opinion as to the proper legal disposition of the case, Steyn authored the following striking passage. It is now necessary to examine the correctness of the interpretation of paragraphs 37 and 37a, involving a blanket ban on interviews, as advanced by the Home Secretary. Literally construed, there is force in the extensive construction put forward. But one cannot lose sight that there is at stake a fundamental or basic right, namely the right of a prisoner to seek through oral interviews to persuade a journalist to investigate the safety of the prisoner's conviction and to publicize his findings in an effort to gain access to justice for the prisoner. In these circumstances, even in the absence of an ambiguity, there comes into play a presumption of general application operating as a constitutional principle. This is called the principle of legality. Ample illustrations of the application of this principle are given in the speech of Lord Brown Wilkinson, and in my speech in Reg. v. Secretary of State for the Home Department, Ex Part Pearson 1998 AC, 539, 573G 575D, 587C 590A. Applying this principle, I would hold that paragraphs 37 and 37a leave untouched the fundamental and basic rights asserted by the applicants in the present case. The only relevant issue in the present proceedings is whether paragraphs 37 and 37a are ultra vires, because they are in conflict with the fundamental and basic rights claimed by the applicants. The principle of legality justifies the conclusion that paragraphs 37 and 37a have not been demonstrated to be ultra vires in the cases under consideration. Declarations should be granted in both cases to the effect that the Home Secretary's current policy is unlawful, and that the governor's administrative decisions pursuant to that policy were also unlawful. Steyn's speech is a fine example of a judicial opinion that demands and repays close, careful study. To begin with, it is impossible to appreciate completely the force of the preceding passage without reading the portions of Steyn's speech in Pearson to which he refers in Sims. There Steyn wrote, "Parliament does not legislate in a vacuum. Parliament legislates for a European liberal democracy, founded on the principles and traditions of the common law, and the courts may approach legislation on this initial assumption. But this assumption only has prima facie force. It can be displaced by a clear and specific provision to the contrary. These propositions require some explanation. For at least a century it has been thought to be in the highest degree improbable that Parliament would depart from the general system of law without expressing its intention with irresistible clearness. Dicey explained the context in which Parliament legislates. By every path we come round to the same conclusion, that parliamentary sovereignty has favored the rule of law, and that the supremacy of the law of the land both calls forth the exertion of parliamentary sovereignty, and leads to its being exercised in a spirit of legality. But it is to Sir Rupert Cross that I turn for the best modern explanation of the spirit of legality, or what has been called the principle of legality. One function of the word presumption in the context of statutory interpretation is to state the result of this legislative reliance real, or assumed on firmly established legal principles. There is a presumption that mens rea is required in the case of statutory crimes, and a presumption that statutory powers must be exercised reasonably. These presumptions apply, although there is no question of linguistic ambiguity in the statutory wording under construction, and they may be described as presumptions of general application. These presumptions of general application not only supplement the text, they also operate at a higher level as expressions of fundamental principles governing both civil liberties and the relations between Parliament, the executive, and the courts. They operate here as constitutional principles which are not easily displaced by a statutory text. Steyn's mention in Sims of the principle of legality as a presumption of general application operating as a constitutional principle, is a direct reference to his earlier discussion in Pearson. In Pearson, Steyn explained that certain fundamental legal principles operate as presumptions of general application. As such, these fundamental principles are not simply interpolated into statutory texts by implication. They supervene upon the constitutional organization of government and the recognition of fundamental rights and values. In Sims, Steyn explained further that the common law principle of legality is one of the fundamental legal principles that operates as a presumption of general application, and that the right to freedom of expression is one of the civil liberties governed by this principle. Moreover, Steyn stated unequivocally in Sims that, even in the absence of an ambiguity in a particular statutory text, the principle of legality operates as a constitutional principle and a presumption of general application. Steyn's dissociation from the rubric of ambiguity in Sims is exceptional. In the minds of many English judges, the judicial role vis-à-vis parliamentary legislation consists solely in enforcing or interpreting statutes. An interpretation depends on some ambiguity, real or contrived, in parliamentary intention or statutory language. By rejecting ambiguity as a prerequisite to judicial action, Steyn rejects this narrow view of judicial authority and responsibility. I have tried to accentuate the relationship between common law review, on the one hand, and the constitutional order and balance of the different branches of government, on the other. I have also tried to show that the common law necessitates a particular conception of this constitutional order and balance, and a particular conception of judicial authority and responsibility, which I have called, respectively, common law constitutionalism and common law review. The principle of legality as defined and discussed by Steyn in Sims supports common law review and common law constitutionalism in three ways. First, the principle of legality is a common law principle that serves to protect fundamental rights and interests in Sims, the freedom of expression from encroachment by the legislative or executive branches. Second, English courts enforce the principle of legality, not just to interpret an arguably ambiguous statute, but irrespective of ambiguity. Third, when viewed this way, the critical inquiry in applying the principle of legality is not whether a particular legislative, executive, or administrative act was ultra vires. The proper judicial inquiry is whether there is at stake a fundamental or basic right, and whether the act in question infringes or interferes unduly with this fundamental or basic right. If so, the principle of legality requires the court to safeguard the fundamental right. I believe this is why Steyn writes, at the end of his Sims speech, that the paragraphs relied on by the prison officials leave untouched the fundamental and basic rights asserted by the applicants in this case, even though the acts of the prison officials have not been demonstrated to be ultra vires. Steyn held in Sims that even in the absence of a demonstration that the prison officials' acts were ultra vires, and even in the absence of any textual ambiguity, the prison officials' acts should still be declared unlawful for violation of the principle of legality, which operates in that case to secure the prisoner's fundamental and basic right to freedom of expression. The prison officials may have had the authority to draft and interpret the rules. As they did, they were not ultra vires. But whatever those rules might say, the prison officials have no authority to infringe on the fundamental rights of the prisoners. The prison rules leave untouched the prisoner's fundamental rights. This is what Steyn means when he says that the principle of legality operates as a presumption of general application. It is always operative, and it always operates as a higher-order principle against which governmental action is assessed. This is common law review. The principle of legality is a principle of English common law that is invoked by English judges to ensure that common law rights of constitutional dimension are protected against infringement by abuses of governmental power. And this common law principle operates at the constitutional level, organizing and balancing the relationships and responsibilities of the organs of government. Steyn's quotation from Rupert Cross in Pearson highlights the dual functions of common law principles as fundamental legal principles and as constitutional presumptions of general application. Moreover, these functions cannot be divorced from one another. Common law review and common law constitutionalism go hand in hand. The principle of legality is a concrete manifestation of the common law's commitment to the preservation of the rule of law. As a common law principle, the principle of legality is a legal standard for judges to apply when reviewing actions taken by other government bodies. As a presumption of general application, the principle of legality requires judges at all times to secure fundamental rights and to maintain the equilibrium of the English constitutional framework. I do not want to overstate matters. Steyn does not claim in Sims that English judges may apply the principle of legality to avoid results required by unjust primary legislation. Sims involved the validity not of a statute, but of statutorily derived regulations and statutorily delegated discretionary powers. Nevertheless, Steyn's opinion in Sims supports the key elements of common law review, and his opinion represents a purposeful step away from an English judiciary, or at least a House of Lords wholly captivated and captured by the dogma of absolute parliamentary supremacy, toward an independent English judiciary fully prepared to accept the mantle of its common law ancestry. The issue of judicial invalidation of primary legislation was not directly raised in Sims. However, Steyn indicates in Sims that delegated administrative discretion is subject to the common law principle of legality operative as a presumption of general application at the constitutional level. If I have read Steyn's speech correctly, this is more than enough to link the reasoning and the result of Sims to the principle and practice of common law review. Judicial review in England proceeds from the principle that administrative decisions are subject to judicial oversight to guarantee the proper consideration of fundamental values in the administration of justice. At the moment when the law intersects with the individual through the exercise of administrative discretion, the government's decisions are always subject to the rule of law as enforced through judicial review according to fundamental common law principles. That the primary legislation may remain viable is, on this account, immaterial. What matters is that the courts must, at all times, even in the absence of any ambiguity, act to uphold the rule of law by ensuring that the government acts in accordance with it. And when the court determines that the government has abused its power, the court can overturn the government's exercise of discretion. As an articulation of legal principle that embraces English common law constitutionalism, Steyn's decision in Sims can reasonably be read as the doctrinal and theoretical progeny of Coke's ruling in Bonham. In both judgments, common law principles are affirmed as maintaining fundamental values of justice that apply without exception to all exercises of public authority. In English administrative law, a little ambiguity goes a long way. This is because, according to the prevailing understanding of judicial review within the context of parliamentary sovereignty, ambiguity permits the courts to review decisions based on delegated discretion, without undermining or challenging Parliament's unfettered authority to legislate. Just as the court's construction of legislation dealing with, say, personal liberty is rationalized in terms of a legislative endeavor that is fundamentally shaped by constitutional principle, so the court's approach to legislation, which creates discretionary powers, may be conceptualized as an interpretive process, which is normatively premised on those values which make up the rule of law. Consequently, when Parliament enacts legislation, which typically confers wide discretionary power, and which makes no explicit reference to the controls which should regulate the exercise of the power, the courts are constitutionally entitled and constitutionally right to assume that it was Parliament's intention to legislate in conformity with the rule of law principle. This means that Parliament is properly to be regarded as having conferred upon the decision-maker only such power as is consistent with that principle. It follows from this that, in the absence of a very clear contrary provision, Parliament must be taken to withhold from decision-makers the power to treat individuals in a manner which offends the rule of law. The task of transforming this general intention into detailed, legally enforceable rules of fairness and rationality is clearly a matter for the courts. Parliament thus leaves it to the judges to set the precise limits of administrative competence. This is the modified ultra vires model of judicial review, which is an attempt by some theorists to balance the rule of law values preserved through judicial review against the assumption that parliamentary sovereignty demands that these values must yield to the supremacy of Parliament's apparent or expressed legislative intentions. The modified ultra vires model incorporates into English constitutional and administrative law the familiar judicial presumption that Parliament always intends to legislate in accordance with the rule of law. And this presumption authorizes courts to resolve perceived tensions between parliamentary enactments and the rule of law by attempting to reconcile the former with the latter. The lingering problem, however, as the previous quotation indicates, is that parliamentary sovereignty still seems to necessitate that Parliament remain capable of legislating in contravention of the rule of law, provided that its intention is expressed in an unmistakably and inescapably clear provision. In such an instance, even the modified ultra vires model would require judges to abandon the rule of law and enforce the legislation. Predicating judicial review on the endeavor to ascertain and enforce parliamentary intentions, as the modified ultra vires model does, means that the modified model cannot disavow the dogma of sovereignty and the sacrifice of legal principle to a sufficiently clear manifestation of legislative will. In Sims, Lord Steyne says that a lot of clarity can go only so far. In his departure from the ambiguity precondition, Steyne determines that even in the presence of a very clear contrary provision, Parliament cannot contravene the rule of law in the delegation of administrative authority, nor can the administrative agency do so in its exercise of that authority. To make this point clearer, it might help to suppose that Sims involved a substantive privative clause. A substantive privative clause is a statutory provision which precludes judges from relying on particular principles of the rule of law as grounds of review. We might imagine that rather than the broad and undefined authority at issue in Sims, the enabling legislation specifically provided that the prison official's discretion could be exercised without concern for the prisoner's right to the freedom of expression or the relationship between that right and the administration of justice. According to Steyne, the judicial obligation in such a case is to preserve fundamental rule of law values contained in the common law by refusing to permit the violation of the individual's fundamental rights. The rule of law applies to and governs all governmental action, and all governmental action is evaluated subject to this prior judicial obligation. Whatever the enabling statute may say, the court's jurisdiction over the substance of core English constitutional values cannot be ousted by legislative means. The conception of judicial authority and responsibility that underlies Steyne's speech in Sims is entirely consistent with the House's ruling in Annus Minnick. The full portent of Steyne's Sims speech can best be appreciated by contrasting his opinion with Lord Hoffman's. Although indicating his agreement with Steyne's reasoning, Hoffman thought it necessary to add only a few words of his own about the importance of the principle of legality in a constitution which, like ours, acknowledges the sovereignty of Parliament. Hoffman discreetly qualified his own adherence to Steyne's claim that the principle of legality operates even in the absence of statutory ambiguity. In the absence of express language or necessary implication to the contrary, the courts therefore presumed that even the most general words were intended to be subject to the basic rights of the individual. In this way, the courts of the United Kingdom, though acknowledging the sovereignty of Parliament, apply principles of constitutionality little different from those which exist in countries where the power of the legislature is expressly limited by a constitutional document. Here we find Hoffman's quiet disagreement with Steyne. Hoffman is not yet willing to agree that the principle of legality operates to prevent the infringement of basic rights, even in the absence of ambiguity. Evidently, Hoffman continues to assume that the court's authority to prevent the infringement of basic rights is limited, at least in theory, by an expression of Parliament's intention to do so with irresistible clearness. This is why Steyne's opinion in Sims is so extraordinary. Read carefully. Steyne's decision provides that even in the absence of any ambiguity, even with irresistible clearness, the government cannot act in violation of the principle of legality. Put differently, there are fundamental common law principles of justice and fairness that operate at a constitutional level. They are always present, always significant, and the government's actions are always subject to them through the exercise of judicial review. In Sims, then, Steyn seems to accept the nucleus of common law review and common law constitutionalism. The English government is, at all times and at every level, a government limited by law. Even if I have read Steyn's speech in Sims correctly, most English judges would still agree with Hoffman's restrained gesture toward parliamentary sovereignty. Some things still must change for common law review to be accepted, even only in the House of Lords. More things must change for common law review to be accepted in the Court of Appeal. And even more things would have to change for common law review to be embraced by English trial court judges. These changes, however, are principally attitudinal, because, as Professor Wade explained, legislative supremacy is based finally on the attitudes of judges, rather than on the pronouncements of Parliament. I have endeavored to show in this chapter that these changes are not nearly as revolutionary as English lawyers and judges might assume. English judges need only claim their birthright. Indeed, English judges sometimes obliquely refuse to enforce parliamentary statutes that conflict with their most fundamental moral convictions. Additionally, as others have argued, English courts already engage in a practice of judicial review under the euphemism of statutory interpretation, which involves the search for or construction of Parliament's implied or imputed intention. One might consider this simply a matter of calling a rose by another name. But in this instance, it seems to me that the rose does not smell as sweet. In the garden of English law, there is value to calling a rose only by its name, because the law grows best without pretext or manure. There is no room in England's majestic legal heritage for fig leaves or fairy tales. B. United States. Things are a bit easier for my argument in the United States. My discussions in previous chapters contain detailed references to American law, and I will not repeat those arguments and citations here. Suffice it to say that the American doctrines of horizontal and vertical stare decisis are not nearly as rigid or restrictive as the current English versions. And there is no doctrine of legislative supremacy in the United States. The model of English legal culture built into the American governmental framework was located in a unique legal historical tradition which guaranteed the fundamental rights and positive liberties of free-born English citizens, rather than the blinkered vision of the Inns of Court men who had largely lost touch with this liberal strain of the common law tradition. Judicial deference to the federal and state legislatures in the United States follows something much closer to the model of deference as respect, which I discussed earlier. This respectful deference, however, was never conceived in the United States as the absolute sovereignty of the legislature or the subjugation of the judiciary. It is not particularly useful to say that the Constitution assigns ultimate authority to any single institution. And although the institutions and procedures established by the Constitution collectively attempt to implement the ideal of government by the people, they hardly could have been intended simply to ensure that government power is exercised by elected officials. The structure of government set up by the Constitution negates any assertion that democracy, in our American constitutional system, can be reduced to the simple notion of legislative supremacy. From this, however, one should not get the idea that the critical difference between the United States and England concerning ideas of legislative supremacy and judicial deference lies in the distinction between the former's written constitution and the latter's unwritten one. Judicial review does not depend, logically or legally, on a written constitution, because the power of judicial review is neither granted nor created by a constitution. This means that England does not need a written constitution as a precondition to the recognition of a power of judicial review in the American sense. This also means that judicial review in the United States need not be understood solely as constitutional review. As I have argued at length, this assumption betrays a legal and historical mistake. The written American Constitution and the unwritten English Constitution are both derived directly from the common law. Our constitutional law, as Sir William Holdsworth put it, is simply a part of the common law. Where the organization of government and the competency, authority, and responsibility of its institutions are concerned, the common law foundation of both nations' legal and governmental systems is their most salient defining characteristic. The U.S. Supreme Court established long ago that the common law must inform the interpretation and evaluation of all legislation, including the Constitution. This is also the reason that efforts to differentiate judicial authority and interpretive paradigms in the United States and England in the context of the debate about the unwritten Constitution, by the presence of parliamentary sovereignty in England, or because of the presence of a written Constitution in the United States, are misguided. Whatever the historical or theoretical pedigree of parliamentary sovereignty in England or constitutional review in the United States, the shared common law foundations of both the English and American constitutions require the realization that one cannot seriously doubt the presence of an unwritten common law constitution in either nation, even if Americans chose to codify certain common law antecedents in their charter document. Moreover, the common law foundations of the English and American constitutions entrench the common law in both nations as the conceptual foundation for the exercise of judicial review, as well as a body of legal principle against which government action may be judicially evaluated. For many American lawyers and judges, however, the Constitution, not the common law, is the defining feature of the American legal and governmental system. The Constitution has become the sacred text of a secular religion. But this sometimes seems to blind the faithful. Just as it is a mistake to suppose that constitutional review is the only form of judicial review found in American law and legal history, it is a mistake to think that the Constitution is more fundamental than its common law underpinnings. The common law, as the legal system operating within a governmental structure, helps to define that governmental structure. In other words, saying that a country has a common law legal system is necessarily saying something about the constitutional organization of its government. Declaring that a nation is a constitutional democracy tells us nothing about its legal system and little about its political and governmental scheme. Constitutional democracies can and do exist with common law, civil law, and hybrid legal systems. Saying that a nation is a common law democracy tells us much more. It tells us something useful about its legal system, and, relatedly, something meaningful about the organization of its government. Saying that a country has a common law legal system is necessarily saying something about the constitutional order of its government, because wherever one finds the common law, one finds legal principles that act to constrain abuses of state power. Wherever one finds the common law, one finds common law constitutionalism. The debate within the Anglo-American tradition about the proper or preferred allocation of governmental powers will continue. But when engaging in this debate, we ought not to allow a preoccupation with democratic political processes to obscure the importance, in England and the United States, of the combination of these processes with common law processes, principles, and traditions. It is a mistake to ignore or devalue the relationship between the legal system and the political system, where a common law system exists within a democratic polity. The legislature's authority must be balanced against the historical, legal, and political import of the common law court's place as a salutary influence on the government and the governed. The legislature does not cede power to the judiciary. The judiciary possesses that power as a co-equal branch of plural government. This is what Koch sought and Marshall secured. The textual and conceptual bases for common law review provide independent justifications for judicial review as reflective of the coordinate position of the common law judiciary within the constitutional organization of governmental and legal institutions. The problems posed by unjust laws help to highlight the unique position, authority, and responsibility of common law judges to ensure the law's development by refusing to enforce unjust laws. The common law judge's position, authority, and responsibility are relevant to the disposition of particular cases and in the organization and allocation of governmental powers. This dual nature of common law judicial decision-making is the signal feature of common law adjudication and common law constitutionalism. In common law legal systems, and in the governments of which they form a part, a particular case can help to shape an entire government. As judges develop the law by deciding cases, the law they develop limits what the government can do in accordance with the rule of law. As a coda to my argument, I want to mention one aspect of common law review that I have not yet raised. Common law review requires of judges a certain combination of qualities. They must have the moral compass and sensitivity to recognize injustice and feel its sting. And they must have the strength of character and will to act on their convictions, even when they must act alone. Not everyone has these attributes, but some do, and they are some of the finest judges of the common law tradition. The remarks of two of these judges, fittingly one Briton and one American, exhibit the disposition I have in mind. The first words are Lord Mansfield's. "I will not do that which my conscience tells me is wrong upon this occasion. To gain the huzzas of thousands, or the daily praise of all the papers which come from the press, I will not avoid doing what I think is right, though it should draw on me the whole artillery of libels, all that falsehood and malice can invent, or the credulity of a deluded populace can swallow. Once and for all, let it be understood that no endeavors of this kind will influence any man who at present sits here." The second passage comes from Justice Holmes. "Law is the business to which my life is devoted, and I should show less than devotion if I did not do what in me lies to improve it. And when I perceive what seems to me to be the ideal of its future, if I hesitated to point it out, and to press toward it with all my heart,